In Pennsylvania and in all states of the United States, there is a limit to how long a patient has to file a lawsuit. Typically, somebody who has been injured by medical malpractice must file their lawsuit within what's called the statute of limitations. And in Pennsylvania, that statute of limitations for an adult patient is 2 years from the time when that patient was injured or should have known that they suffered an injury which may have been caused by healthcare. There's also some important exceptions to that 2-year statute of limitations. One is for a patient who was a minor at the time of injury. A minor actually has until their 20th birthday to file a lawsuit. In other words, their 2-year statute of limitations does not begin until they reach the age of majority in Pennsylvania, which is considered the age of 18. But in reality, parents of a minor or their legal guardians will typically reach out to a law firm like Lupetin and Unatin and start the process of investigating a medical malpractice case while that patient is still a minor. And that's important because you don't want to wait up to 18 years after the events in question to investigate a lawsuit. Memories are lost, evidence gets misplaced. Another important aspect of the statute of limitations law in Pennsylvania involves cases involving death. In any medical malpractice case involving death in Pennsylvania, there is 2 years from the date of death within which the legal representative of that individual's estate must file a lawsuit against the healthcare providers involved. A lot of people come to us with a little bit of an understanding about something called the discovery rule. And the discovery rule is an important part of the law in Pennsylvania, which stops the period for the statute of limitations from starting until some later date. And we often see it in cases involving the failure to diagnose cancer. It comes up in a scenario where a patient may have a CT scan or some other radiology study many years prior to actually being diagnosed with a mass. And then we or some other healthcare provider goes back and realizes that that radiology study 2-3 years previously showed that same mass but went unreported by the radiologist, or maybe was reported but the doctor didn't do anything about it, didn't tell the patient that they had a mass. But the discovery rule comes up in other contexts as well. The important takeaway is, as a potential client or as somebody who is a patient who may have been harmed by medical malpractice, don't try to figure out the discovery rule for yourself. And as a general rule of thumb, if you believe you may have been injured as a result of medical malpractice, contact a medical malpractice law firm like Lupetin and Unatin right away, as soon as you have an opportunity to do so. And we will analyze whether the discovery rule applies or some other exception to the 2-year statute of limitations.